Your trial testimony will make or break your case, period. No matter how strong your evidence is, if you fail to communicate effectively with a jury, you risk losing everything. The trial is the pinnacle of your lawsuit. It is the moment of truth and your opportunity to have your day in court. Not only is what you say important, but how you say it and how you present yourself will significantly influence the judge and the jury. I have tried numerous cases over my career, and I've done it on both sides. I've done it on behalf of the defendants who are defending lawsuits, on behalf of insurance companies, and I've done it on behalf of individuals who have been injured through the negligence of others. Clients often ask, how do I dress when I go to court? My answer to them is simple, and it's always the same. Dress as if you are going to a funeral. You need to be comfortable in your own skin. You need to wear clothes that you are comfortable with, but you need to dress neat. You need to be well groomed. You need to take into consideration that the jurors are deciding your case, take this very seriously, and they will come to court dressed appropriately. Another question clients often ask is, do I have to be there for the entire time? And my answer to them is always the same. Yes. If you expect 6 jurors to take time out of their lives, to take time away from their jobs and their families, you need to be there, because these are the people who are going to be deciding your case and whether or not to award you money, and if so, how much. It's important for clients to understand what to expect when they go to the courthouse. When you walk into the courtroom, at a minimum, there will be the judge, there will be a court reporter, there will be a court officer, there will be your attorney, and there will be the adverse attorney. In a lawsuit, there is a plaintiff and a defendant. The plaintiff is the person who is injured. They are the person who's bringing the lawsuit. The defendant is the person who is being sued and is defending the lawsuit. Now, unlike in a criminal case, if you're the plaintiff in your own lawsuit, you pretty much have to testify. Plaintiffs do not always testify. Sometimes they're incapable of testifying for medical reasons. For the most part, if the plaintiff is able to talk and to testify, the plaintiff needs to testify in their case. Your testimony is evidence and is taken into consideration by the jury as to what happened in the case. Now, as the plaintiff, your attorney can decide when to call you. You may be the first witness, you may be the last witness. That is a decision that is determined by strategy, and sometimes it's determined by availability, because depending what other witnesses are available, if there is an expert witness and the expert is only available on the first day of trial, well, your attorney may not have a choice but to call that expert first and call you at a later time. There really is no benefit to having the plaintiff testify other than first or last. You want to have them testify first because it makes a strong impression if they make a really good witness. You want to get your facts in out of the box. Sometimes, depending on the case, depending on the other evidence, depending on the other witnesses, maybe you want to have the plaintiff testify last. Maybe you want their testimony to be strong before you rest your case so the jury ends on a high note. Now, the key evidence we're looking for from you is, how did the accident happen? What injuries did you sustain from the accident? And how has this affected your life from the date of the accident to the present? What kind of medical treatment have you had? What kind of medical treatment do you expect? You were not expected to testify to this in its entirety. Sometimes there will be medical doctors to testify regarding future pain and suffering, but you really need to testify regarding the basic elements. It is normal to be nervous. I have not met a witness who is not nervous going into the courtroom when they are about to testify, and even while they're testifying. That is completely normal, and it's understandable, and juries will understand that, and juries will relate to that. But it's important to use that nervous energy to your advantage. Avoid fidgeting. Avoid looking away. It is important to always look at the jury. It's important to listen to the question. It's important to take your time when answering. It is also important that if you need a break, if you're nervous to the point where you need water, you need to use the restroom, you can. All you have to do is ask, and the judge will grant the break. You can't do it in the middle of a question, but you can ask for a break. If you feel emotional while you're testifying, it's okay. It's okay to cry, and it can also be beneficial if you show emotion and you cry. How you react on the stand is important, because the jury is observing you from the moment you walk into the courtroom to the time when you take the stand to how you get off the stand. They're watching you while you're in the audience, while other people are testifying, how you react to things, and they make mental notes. So it is always important to not only dress like you were at a funeral, but act like like you were at a funeral. And throughout the whole trial, you need to be respectful to everyone involved in the process. Not only the judge, not only the jury, but to the adverse attorney, to your attorney, other witnesses. You need to show respect for the court and for the people that are involved. When you are on the witness stand, avoid being sarcastic, avoid being a wise guy or wise gal, and listen to the questions and answer the questions. I once had a witness start rolling his eyes and laughing at me. It was almost like out of Goodfellas.
I mean, what's funny about it?
So what's funny? You're not asking me good questions. Well, it's my job to ask the questions. It's your job to answer them. You don't get to determine how I ask my questions. And we kept going back and forth to the point where the judge got involved. Judge yelled at him, judge yelled at me, but it was a bad look for him. Now that we've established what to expect when you get to the courtroom, how to act when you're in the courtroom, how to act when you're on the stand, now we need to establish what do you need to do to crush a trial testimony. How do you win your case? How do you make the best witness ever? This is how. There is one word to ensure you win your case and you're the best witness you can be. That word is preparation. Preparation, preparation, more preparation, and more preparation after that. When we're getting ready for trial and we're starting to talk about scheduling the preparation, clients will ask, how many times do we have to meet? The answer is always the same. As many times as it takes. There is no minimum, there is no maximum. You meet with your attorney until you are comfortable, until your attorney is comfortable, and until you know what you are going to testify to, backwards, forwards, up, and down. One of the first things we do when we're getting ready for trial is we send the client copies of all their statements, their deposition testimonies, otherwise known as examination before trials or EBTs, any statements they've written, any documents in which they've given statements. We want to make sure that they are familiar with what they have previously said because the trial is usually years later from when the accident happened. And it's usually years later from when they made these original statements, whether it's on the police report, whether it was a statement in a hospital record. The trial is years away, so they need to be reminded of what was said because over time, people forget, which is natural. Now, the difference between your trial testimony and the testimony you've previously given at your deposition or examination before trial is that at the examination before trial, the other attorney was asking you questions. During the trial, it's your attorney who will call you as a witness. It's your attorney who gets to ask you the questions, and it's your attorney who gets to set the pace and establish what they want. And usually they'll go with background questions to establish who you are and what kind of person you are and how you spend your activities of daily living. There are many things to paint the picture of who you were before the accident and how this accident has affected you. Now, this should be done during your preparation with your attorney. They should go over what your direct examination is going to be, what your cross-examination is going to be. One tool I use frequently is a timeline because people usually have a better recollection when things are presented to them in a chronological order. If you give an answer that is inconsistent with a prior statement or prior testimony, then the adverse attorney can do what's called impeach you with those prior statements. There is a deposition transcript available. The attorney will whip out the transcript. They will turn to the page where the question and answer is, and they will ask, do you remember giving testimony on this date and time at this location? Your attorney was present, right? You had an opportunity to review your transcript and go over it with your attorney. You met with your attorney prior to giving this testimony, right? And the testimony was given a year, 2 years, whenever it was before this. And wouldn't you state that your recollection was better then than it is today? I want to direct your attention to page 39, line 13. Question, and they will read the question. Answer. They will read the answer. Witness, do you recall being asked that question and giving that answer? Yes or no? And the witness has to answer, yes or no. A lot of times the witnesses will not answer the question directly and they will fumble. And the attorney will press and they will press and they will press because it's a recorded statement. There's no dispute that you gave that testimony previously. They may ask if the answer is different, do you want to change that testimony? But there's a lot of things that the attorney can do when you give an inconsistent statement. So the best thing is to answer the question, own it. If there's an explanation, your attorney will have an opportunity to question you again, and you can fix it or explain it. Testifying is a 3-step process. First, Listen to the question. Do not anticipate what the question is going to be. Listen to the question, let the attorney finish the question, then answer it. Second, you need to understand the question. If you don't understand the question, you need to let the attorney know that you do not understand the question. Finally, answer the question. Do not volunteer any information. Answer the question that is asked of you. Do not provide any more information. Do not provide any less information. Do not avoid the question. Answer the question. 5 best answers you can give during cross-examination are yes, no, I don't know, I don't remember, and I don't understand the question. Keep your answers short, to the point, and responsive to the question. Question is, did the defendant stop at the red light? The answer is yes or no. And if you can't answer the question yes or no, say, I can't answer the question yes or no. Sometimes the question is misleading. Sometimes it's a compound question. Sometimes it's intentionally misleading. Sometimes it's unintentionally misleading. So if they were to ask you, isn't it true that you refused treatment at the accident scene because you weren't hurt? You may not be able to answer that question yes or no, because you may have refused treatment at the accident scene, or maybe treatment wasn't offered to you and you didn't refuse it, but it may not necessarily mean because you weren't hurt. It could mean because EMS was taking too long to get there and you were in so much pain, somebody had to take you to the hospital. Or it could mean that you were uncomfortable because EMS were treating so many other people and you wanted to get to the hospital. There could be numerous answers, but in that case, you have to tell the attorney, I can't answer that question or I don't understand the question. Your attorney will have an opportunity to rehabilitate you and to correct whatever happens on cross-examination if you're unable to get your point across. There is something called redirect and recross. So what first happens is your attorney questions you at his direct examination. When he's finished or she's finished, the other attorney gets to do a cross-examination. And when that attorney is finished, your attorney has the opportunity to get up and do what's called a redirect, ask you more questions, but those questions are limited to the scope of what was brought up on cross-examination. And when the redirect is finished, the other attorney has an opportunity to do recross, and the scope of that examination is limited to what is brought up on redirect. And this can go back and forth until there are no more questions. A lot of times, there's a direct and a cross. There's no redirect, no recross, and it usually doesn't get too far out of control, but I have seen it go back and forth several times. Let your attorney do their job. And when you're done with your testimony and the judge excuses you, you leave the witness stand with your head held high. Don't show any emotion. No fist bumps how great it went. Don't look disappointed. Don't look happy. Don't look sad. You can look over at the jury, but have a solemn look as best you can. Again, pretend you're at a funeral. Now, my name is Phil Rizzuto. I have litigated cases in all 5 boroughs of New York City, and what makes me unique from other attorneys is I've done it on both sides. I have represented municipalities, large corporations, insurance companies, and I know how they manipulate the system, and I know what their strategies are in defending these types of cases. And I've also represented individuals who have been injured by these large corporations. I've done it, and I've tried a lot of cases all over the place. If you have questions, or if you or a loved one have been injured through someone else's negligence, ring Rizzuto at 855-RIZZUTO. And if you found this video helpful, like, subscribe, and I will see you at the next one.